Welcome to all of you. My name is Vincent Gautret. I'm a professor at University of Montreal, Faculty of Law, and holder of the Wilson Chair in E-commerce Law. And welcome to the fourth activity of the Club de Lecture, what we call in French a kind of book club, where we try to highlight a work that we feel is important in the literature linking law and technology. So this club de lecture is an initiative of the law and cybersecurity axis of the OBVIA. OBVIA, for people who don't know this acronym is Observatory working on social aspect of AI and technology. And with this sac de lecture, we launched a month ago with Professor Anne-Sophie Lin at the University of Sherbrooke. She couldn't be here, unfortunately, today. We launched this book club for a very simple reason. Just because as researchers, we don't read so much, and it is important to be aware of what other colleagues working on. So today we are going to talk about a book that has had a major impact in the field of digital law. A book that also stands out from the usual literature insofar as, and the title is very clear, it shows a deliberate desire to promote the use of technology in general and AI in particular. So thank you so much. Thank you so much, Abdi Aidid and Benjamin Alarie, to be with us for presenting your book named The Legal Singularity, How Artificial Intelligence Can Make Law Radically Better. It is a real pleasure to welcome you today and to welcome some colleagues from UST, with whom we are not so accustomed to working with, but was work we always watch with great interest. And thanks a lot to my colleague, Patrick Garon-Sayegh. Patrick will be in charge to propose a response to that book. So just a few words about the speakers. It will be very, very short. So first, concerning the others, Abdi Aidid is a graduate of Yale Law School and assistant professor of law at UFT, and Benjamin Alarie, of the Oslo Chair in business law in the Faculty of Law, also in UFT, and he is an affiliated faculty member at the Vector Institute for Artificial Intelligence. Concerning Patrick Garon-Sayegh, as I mentioned, is a pretty new colleague at the Faculty of Law at UDM. And for sure, he was a perfect match to propose a response to Abdi and Ben's book, given his interest in the connection between law and science and philosophy of science. And I think you are also a graduate student. You have done your PhD in UFT, yeah. If I'm okay. So before giving the mic to Abdi and Ben, the format is very simple. Authors of this book will have 30 to 40 minutes to present their work, and Patrick will give his answer in 15, no more as 20 minutes. So after that, we are supposed to have maybe 20 minutes of questions with the audience, just 20 because one of the speakers has a plane to take, so we need to reduce our activity and finishing it at 1:45 and not 2 as it was initially scheduled. So please, and thanks again, Abdi and Ben. So please, you have the mic.
Okay, fantastic. Thank you so much for the invitation to engage with the book club and to talk about the legal singularity. We're going to split our time. I'm going to start, and what I will do in my remarks is give a little bit of the context, the backstory, where this book is coming from, and give you a little bit of the history. And then I'm going to kind of set the stage just to make sure that everybody is on the same page about how technology is already rapidly progressing at a rate, that's very exciting to some, very alarming to others. But it really is the context in which Abdi's then going to take over and take the mic and talk about the several of the claims that we make in the book, which I think will be a very nice setup to then pass it over to Patrick to share his remarks, and then we're going to open it up for Q&A. So in terms of where this book is coming from, it's really, really interesting. I didn't imagine myself doing this, being part of this wave of AI when I first became a faculty member here at the University of Toronto back in 2004. I'm a tax specialist, so very interested in fiscal matters, fiscal federalism, tax law. I've been teaching tax here for the last 20 years. This really came about when I led an effort to reform the first year curriculum of the law school back in 2011 as associate dean of the faculty. And some senior colleagues warned me, Ben, you shouldn't do this. Trying to reform the curriculum is a fraught matter, and people get very upset potentially with each other because people have different strongly held views about how best to deliver a legal education. And said, okay, well, maybe this will be different. We can handle it. Just to give you a spoiler, it was a very successful curricular reform, and it happened. It took a little bit longer to get through than I expected, but it was very successful. One of the key thoughts is very relevant to the genesis of this book, though, which is it had been 40 years before we had a major reform of the law school curriculum at the University of Toronto. And so when I sat down, that was one of the facts that I ruminated on. It's been 40 years. And so that got me thinking, if we are going to reform the curriculum, we need to do so in a way that anticipates what's likely going to be influencing what the content of legal education should be for the next 40 years. And then that thought got me very curious about, well, we're seeing Moore's law, we're seeing exponential increases in computational power. This is that has major implications for things like machine learning, artificial intelligence. And then I started thinking about law as prediction, the way that we do so much of teaching about law. It's obviously very case-based. It's very analytical. But if you relax the constraints on computation, and you might regard law as a matter of prediction, and this is kind of the Oliver Wendell Holmes kind of thought about law. It's a prediction theory of law. I started to really think about, wow, AI is going to likely have a major impact on the future of the legal system, how we regulate ourselves, how we deliver a legal education, how we think about the legal profession, what's the role of humans in the legal system in the future versus machines. And I got totally preoccupied by all of this stuff. And it led me to do a couple different things. First of all, we got the curriculum reform over the line. And it was kind of back to the future for the University of Toronto because we decided to focus on the core theoretical kind of grounding, interdisciplinary academic grounding of our legal education here. And so that was well received, and that was consistent with what I thought future lawyers and future legal education should be really focused on. It wasn't about let's try to teach our students coding, for example, or teach them how to use these systems. These systems are going to be constantly changing. But we got the curriculum reform done. It got me very interested in writing about the law law and future technologies and how that's going to work. And it also caused me to found a company called Blue Jay with two of my colleagues from the law school, Albert Yoon and Anthony Niblett. And Abdi subsequently joined Blue Jay on his return to Toronto from the US, where he had been working after finishing his JD at Yale. One of the academic pieces that I published, I think it was in 2015 or 2016 in the University of Toronto Law Journal, was kind of thinking about if we relax any constraints on computational power, what impact might that have on law? And so this piece is a relatively short piece published in the University of Toronto Law Journal called "The Path of the Law Toward Legal Singularity." It was 7 pages or 10 pages. It was pretty short, but the subsequent reception of that piece, it stirred up a lot of commentary, and a lot of people were critical of this idea of a legal singularity and having computers, basically computational law, make law relatively predictable. And I think a lot of the critiques were relatively unfair and kind of created a straw person out of the argument, and kind of created the straw person and then beat up the straw person. And Abdi and I were spending a lot of time talking about this. I'm like, Abdi, like, I'm surprised by how much attention this idea is getting, that the law is going to become radically more predictable. And I think a lot of the critiques are relatively unfair, but I understand, because this original piece was just so brief, and we just couldn't do a sustained treatment. I didn't do a sustained treatment of all of the thinking. And plus, after it had been published, there was a lot more thinking, and Abdi and I had tons of conversations about this in the context of his work as the vice president of legal research at BlueJay, which is a legal technology company using AI in the law. And so it was after a business meeting, in fact, at BlueJay, that I said to Abdi, maybe we should write a book and we can give a sustained book-length treatment of the idea of the legal singularity and defend it from its critics, but also, further develop a lot of the ideas, and we could do some more sustained thinking about it. And Abdi was game. And in fact, I think he said, Abdi, correct me if I'm wrong, but I think you said, Ben, I've been thinking the exact same thing, which is pretty great.
Yeah.
So that's where the book's coming from. We started talking about these issues in 2017, 2018, started working on the book shortly thereafter. And of course, from that time, we're now in 2025, it's 7 or 8 years later. A lot of what we were imagining at that time has now come to pass, and there's a line of sight to the continued development of the technology. And so maybe I'll just share my screen now and do a little bit of this context setting about where the technology is now and where people expect the technology to be going in the next few years before I turn it over to Abdi to talk about some of the core contentions in the book. And so if this screen sharing has been successful, you can see a website. It's called Metaculus, and this is a forecasting market. What's really interesting is this, forecasters can go on this system, they can make predictions in response to different questions. This question is, when will the first weekly general AI system be devised, tested, and publicly announced? And there are criteria about what a weekly general AI system needs to be able to do to make the answer to this question, yes, this exists now. What you can see is that the community prediction about this is the median is 2026, December 23rd, 2026. So less than 2 years from now, this forecasting group of 1,500 people are expecting that to arrive within the next 2 years, to have a weekly general AI system. And what does that actually mean? So it means it needs to be able to reliably pass a Turing test. So a Turing test is a test of whether, if you're interacting with the system, if you cannot reliably distinguish a computer system from another human with which you may be having a conversation, able to score 90% or more on a robust version of the Winograd Schema Challenge. So these are very complex kinds of linguistic interpretation questions that humans find relatively easy, but artificial intelligence systems, NLP systems, have traditionally been challenged by. But a 90% or better score is basically human level performance on this. Be able to score at the 75th percentile on the SAT using just images of exam pages. So it's better performance than 3/4 of university hopefuls. And then be able to learn the classic Atari game Montezuma's Revenge and explore all 24 rooms based on the equivalent of less than 100 hours of real-time play. So, and it needs to be kind of a single system that can exhibit all of these things, not a collection of subsystems that is specially trained to accomplish each of these tasks, but something that's capable of strong performance across each of these areas. So this is interesting. So I think this is consistent with what we're seeing in the development more generally, and you can track over time how these predictions have changed. So for example, if you go back to early 2022, the community of predictors at that point did not expect these kinds of capabilities until October 2038. So this has accelerated massively in the last 3 years. That timing has approached us by 12 years. So there's clearly an acceleration in the expectations about this. Of course, at this time, this is when Abdi and I were finishing the initial draft of the legal singularity. So we don't make any concrete predictions about when these systems are going to become more competent in the book. And we had conversations about this. Should we make predictions? The answer was, let's not. So this is very interesting. So this weak general artificial intelligence system is expected to be around the corner in the next couple of years. This next prediction market is after a weak artificial general intelligence system is created, how many months do you expect it to take for the first super intelligent artificial intelligence to be created? Now here, this is in months, less than 3 years, 34.7 months. So if it's going to be 2 years from now until we get a weak artificial general intelligence, within 3 years after that, the prediction is there's going to be a super intelligent artificial intelligence created. And so that's around the corner. And so there are criteria there. I won't go into it because I want to show you one more before I turn it over to Abdi, which is, when will the first general AI system be devised, tested, and publicly announced? And this is, the expectation is roughly 6 years from now. So February 1st, 2031 is right now the core prediction. This is not very far away. So this is closer in time to today than when we started writing the legal singularity back in 2017, 2018. Here, this is very interesting. To be this kind of system, it has to be able to reliably pass a 2-hour adversarial Turing test. It needs to be embodied. So it needs to have robotic capabilities and be able to construct a circa 2021 Ferrari 312 1/8 scale automobile model. So taking a kit and just given the instructions and the parts, be able to open the kit, read the instructions, and assemble this model automobile. So that requires fine motor skills, dexterity, understanding the instructions, have high competency at diverse fields of expertise, and then be able to code at a very high level. So generate computer code and score over 90% on interview level problems. This is the APPS benchmark is something that has been developed to test the coding proficiency of different AI systems. So my point in showing everyone this stuff is the community now of researchers expects a lot of this to be around the corner. A lot of this technology is around the corner. And this is the right kind of lead into Abdi's discussion about, well, what does this mean for law? And what do we think it means for law? And I'll turn it over to Abdi now to kind of talk about some of these central contentions from the book.
Great, thank you, Ben. I should say, when I joined BlueJay as the director of legal research at the time, I had left practice in New York. And at the time, BlueJay was mostly doing machine learning prediction of case outcomes. And today, some of you will be familiar, BlueJay, which Ben still runs, I've since left the company, has harnessed generative AI to give sort of plain spoken answers to important tax law questions. And so part of what happened is that the technology caught up in meaningful ways to the vision. And that's a little bit of the story of the legal singularity. So we are law professors, in addition to being what you might consider technologists. And so law professors love a bit of theory. And so the theorist, which I think best captures the story that we're telling in the book, is Oliver Wendell Holmes. You'll all be familiar with the famous prediction theory of law, which actually came out of what started as an address to law students called The Path of the Law. And as some of you know, there's a couple of famous quotes in the text. One is, "The prophecies of what courts will do, in fact, and nothing more pretentious, are what I mean by the law." So in Holmes's rendering, the law is really an attempt to forecast what future courts are likely to do. And if you think about that, that goes beyond just making predictions about what the law is, but it really is sort of the way that we make legal statements. So, if I say I own a home, I'm maybe saying that my name is on a deed somewhere, or there's some document that has recorded my interest in the home. But what I'm really saying is that if you sort of tested me, or if it came down to it, I'm confident that if you were squatting in my home, that the authorities would vindicate me, right? There's a prediction as to what's likely to occur that underlies all kinds of legal statements. And that's really what clients expect of lawyers, just take it to legal practice. If you were a lawyer and you had a storefront office and you hung a shingle and you said, come get your legal help here, and someone walked in the door and they said, "Hey, I got into a fight at work. I'm being charged with assault and battery. Can you help me?" They would be really frustrated if the first thing you did was just recite the contours of the doctrine, right? What they want to know is, what's going to happen to me? What can you do for me? What is my risk exposure? Which is the same in, complicated tax law questions, right? If someone is trying to structure a transaction that goes across borders and involves complicated capital structures, they want to know, is this likely to attract regulatory scrutiny? What would the treatment be from the regulators if it came down to it? What would our sort of defenses be? What would our explanation and justification? And then the work of the lawyer would be to, based on their forecast, do all of the constituent parts that make up the legal work, right? And the thing is, Holmes was thinking about this in the late 19th century. In fact, famously in the same text, Holmes said, "The lawyer of the past." He actually said, "The man of the past." The man of the past is the lawyer of the past is the man of black letter law. The lawyer of the future is the master of statistics and economics. So it was an early case for interdisciplinarity in the law. But the long and short of it is, this was law's long-held ambition. If what we do is attempt to forecast what the outcomes are going to be, and if legal statements are imbued with that forecast of what outcomes are going to be, well, we're all engaged in making predictions. And if we understand that technology has, in some limited ways, a superior capacity to synthesize the productive inputs that make up those predictions, then maybe it can be a big part of the prediction, right? And that's the insight that that's the conceit that underlies a lot of what we're saying here. And so, to the extent that there's some vindication for Holmes here, where we have a little bit of that on offer. Okay, so the book, The Legal Singularity, is a pretty short book relative to the size of the topic. And part of that is for a couple of reasons. One is, it was our attempt to provide a framework and some important vocabulary and a sort of common arena for conversations about the future of the legal profession, the future of law's institutions, law's ecosystem broadly construed. So in many ways, it was us trying to sort of cast down the gauntlet and then invite people to do follow-up work, to elaborate on some of the principles, to contest them. And so the book makes a set of claims that invite significant dialogue and debate. At the same time, as Ben mentioned, the book, I think we maybe submitted the manuscript like just before ChatGPT came out. We made some revisions to anticipate some of the forthcoming technological shifts. But we don't make significant predictions about what technology is going to look like beyond the ones that we think are historically supported, right? What's likely to happen. And so the book is supposed to invite this kind of dialogue. And the way that we did that is by making a set of contentions that I want to test with you all here and invite folks to respond to and ask questions about. So first and foremost, this notion of the legal singularity, which Ben referenced, is this future state in which the law is going to be knowable everywhere on demand. where legal uncertainty is practically eliminated, right? And if you think about legal uncertainty, that can manifest in a couple of different ways, right? There's the legal uncertainty, which is we just don't know what the law is, because it's hard to parse or it's hard to find, right? It's hard to put our finger on. There's legal uncertainty because the law hasn't caught up to major developments. Maybe some of our analogies are a little bit rough. The law is slower to contend with a rapidly moving set of social facts. I think often about the development of new financial instruments like cryptocurrencies, for example, right? Our conversation about cryptocurrencies relates to, does it feel like a commodity? Does it feel like a security, right? I teach privacy law, and one of the things that we talk about is how the law, as it relates to the reasonableness of search and seizure, for instance, is really, not specific to modern technologies like cell phones or laptops. It's us trying to think through analogies. Is the laptop unlocked, which would make it more like a garbage receptacle, or is it locked, which would make it more like a briefcase, right? And so some legal uncertainty is a result of us creating these analogies that have to travel a long distance. Some legal uncertainties because the law is underspecified and underdeveloped. We don't have law for some significant things that are impacting us in major ways in society. The kind of legal uncertainty which we can't stand, which maybe we all should agree shouldn't exist, is where the law has aspired to some clarity, but it's difficult because of our own limitations to put our finger on it, right? So for instance, the question, which is one of the early predictors that Ben worked on developing, that I helped to refine, was a simple question about, is a worker an independent contractor or an employee in certain circumstances, right? This is like the one of the major debates of the modern gig economy. Is an Uber driver, is a pizza delivery person, a DoorDasher, properly classified for tax or labor purposes as an employee or an independent contractor? That's one of those questions which ought to be knowable. Why? Because it's not like we're looking beyond the existing authorities to try to answer that question. There's thousands of cases. The only problem is, and the sort of rate limiting factor on the quality of advice that we can give is, can we wrap our head around all of the cases in sufficient time? And so part of what technology purports to do in these contexts, and what AI and initially machine learning, now more generative AI techniques purport to do, is start us off on a higher floor where, if all I can do is read a sampling of the cases, because I have to sleep, I have to take care of my kids, there's a limit to what I can access, there's a limit to how much I can read in a day, and I can't hold thousands of ideas constant in my mind at one time. Well, technology has improved vantage point in that context, because it is tireless, can work around the clock, but most importantly can synthesize large volumes of data. And so why not leverage it for what it's good at? And then I can do the work of maybe reading that sampling of cases I would have read anyway. But now I have the benefit of this huge mechanical assist, right? That's the idea behind the advent of legal prediction, which really makes the singularity possible and pushes the dynamics that Ben was describing into motion. Since then, we've gotten, I don't know how many times better at doing this, right? Not only were those early sort of machine learning models refined and improved because of more data, because of us getting smarter about the different ways to make those predictions, but as a matter of fact, there's all kinds of newfangled data science techniques that go even beyond that, what is effectively that 20th century math, right? And so the question for us used to be, can we prove that this works? The question now is, how do we absorb it into our institutions, into our infrastructure, into our ecosystem in ways that are sensible and responsible, and in ways that meet our approval, right? And respect the rule of law principles? Because respectfully, I submit to Ben, Pratik, Vincent, everyone here, the ship has kind of sailed on whether or not this stuff is going to happen, and whether it's good enough to perform some measure of legal tasks, right? Okay, so with that said, we make a couple of arguments in the book about things that we think are on order for the future of the legal profession. So one possibility is that because of the advent of legal prediction, because of the proliferation of artificially intelligent techniques, when leveraged against legal data, we are able to actually make better law, right? Law, we say, will become massively more complex, but also more deeply specified, and legal consequences can be fairer, clearer, and more efficient. So one component of this is just a byproduct of the proliferation of big data, where we can just have a better sense of outcomes of cases if we're able to crunch more numbers, ingest more information about the world in which and the context in which the legal decisions are made. But also, importantly, we no longer have to make the trade-off that we used to between. Actually, I'll explain this point by telling a very, very quick story. I teach civil procedure, and one of the things that I do in my life outside the classroom is I serve on a bunch of different task forces related to access to justice. So my early publications are about access to justice. And so I'm working with judges and lawyers on trying to figure out some what are called A2J solutions. And reflexively, the go-to solution that people have for our modern access to justice problem is simplification. Let's simplify the law, right? The cartoonish version of that is you might see legislators. I remember Ted Cruz one time showed the tax code in a single page. It showed the big volume of the tax code. He said, we really ought to get it down to 2 or 3 pages, right? And that makes a lot of sense when you diagnose the main problem of access to justice as the illegibility of law, right? It's hard for us to understand. It's complicated. Lay people can't wrap their head around it. You need these privileged interlocutors like lawyers who have these ridiculously elaborate educations to understand it. But the problem is that the world in which law purports to regulate is complicated, right? So Dodd-Frank, the big piece of financial legislation that emerged after the 2008 crisis, was called and derided as the largest law ever. But in reality, it had to be big. It had to be complicated. It had to be deeply specified. Now, some of that's because of inartful drafting, but it's also because the law had to contend with the emergence of things like collateralized debt obligations and all these new financial instruments that demanded highly specified responsive law, right? And so part of what we're arguing in the book is if you can get to a place where you can have the law that is deeply responsive to the evolving social conditions, that can contend with the most complicated circumstances, and you can eliminate the inaccessibility, illegibility problem by using, say, generative AI techniques to better understand what the law is saying, or by using machine learning techniques to predict how legal outcomes might look in that context, you don't need to simplify, which risks making the law under-inclusive. And the complexity itself is not a automatic evil in the same way, right? So that's one of the claims that we make in the book that I'm keen to hear from folks about. Now, some of this also goes to lawmaking and the process of lawmaking, right? One of the reasons we opt for sometimes imperfect standards in our legal system is because we can't forecast the various social situations that might emerge, right? We like, if we're trying to do things like determine let's think about this let's have a meta conversation about regulating AI. Part of the reason that we are not going to succeed in having a deeply one comprehensive integrated AI law is because we can't make predictions about what kinds of technologies are likely to emerge in the future. And if we cast the die today, then who knows if the law is going to have a long shelf life. Well, if you can make better predictions about what's likely to happen, maybe not in the context of what technologies are going to emerge, but in the context of traffic and the environment and tort context and the economy, then you can actually make law that is better calibrated for those end purposes. Improve dispute resolution. So this idea that if we can understand what the law is, if the law becomes less elusive, if we can actually put our finger on what the law is, then we can actually move beyond just trying to identify it and get into conversations about what the law ought to be, or even at the case-by-case level, what the appropriate sanction is, what the socially productive outcome is, etc. I deal with this problem all the time because I teach torts, and one of the things that I constantly tell my students is, hey, the tort law will implicate your moral intuitions, and it's a great subject because it's accessible, and you will all have ideas about how these cases ought to be resolved, and the cases are going to deal with facts that are important to you or things that you're likely to confront in your everyday life. And then we read cases like Blackwater and Plint, right? The very famous Supreme Court of Canada case about whether or not the government of Canada is liable for these gross abuses at a residential school, specifically the Alberni Indian Residential School in British Columbia, right? This is a case that deals with perhaps the most important subject matter that we could be discussing in the law. But if you read the case, it's only nominally about that. Why? Because the case gets resolved on a debate about the contours of vicarious liability and trying to identify the right and appropriate legal structure for thinking through vicarious liability, and the crumbling skull doctrine, the eggshell skull limitations periods, right? If you get handed that case to a non-specialist and said, what's this case about? They might say 3 or 4 things before they mention it's about historic recompense for gross abuses at residential schools, right? And part of the challenge there is that lawmaking, dispute resolution has become preoccupied with identifying the law. Imagine a world where the law is more stipulated, where there's at least a common understanding of what the law is, right? It's an audacious thing to imagine. But imagine that. Imagine what then would we be using our dispute resolution mechanisms for? And part of what we're contending in the book is that we would be using it to make more normative, policy-oriented judgments, which can be more attentive to things like the social good. And of course, there's a well-rehearsed argument in there that other folks have made extensively since about how dispute resolution can become faster and more efficient, in part because it would reduce research and investigation costs. It might technology might be effectively leveraged to do things like evaluate evidence, et cetera. I won't continue to rehearse those views. The key one is this idea that judging can begin to resemble what the lay public believes it already does in a world where we're using artificial intelligence tools. Universal legal literacy, this idea that the law will be knowable on demand, that AI agents will help people understand their obligations in real time. The long and short of that idea is one that deeply excites me, which is the possibility of just people being able to get answers to legal questions more quickly and more effectively. And people being able to get answers to legal questions in ways that they can absorb and accommodate into their everyday life. I think that it's pretty jarring how difficult it is to get answers to some garden variety legal questions if, say, you're operating a small business in a highly regulated environment, or if you're an individual that's trying to engage in some estate planning or something like that, right? You, of course, have to go and procure expensive legal services sometimes, or worse yet, the worst of all worlds, is you go at it alone and make significant errors that neither protect your legal rights nor help you achieve the objective that you wanted the advice for in the first place. And so there's a possibility of more retail applications of these technologies, which down the line can improve legal literacy. And this relates a lot to the next point that we make, which is that lawyering will evolve and in fact can and maybe perhaps even has to evolve, right? We strategically place this claim after the claim about universal legal literacy because the most common question that we get is, well, what does that mean? If people are getting answers to legal questions, then what are lawyers going to be there for? And I like to respond to that in 2 ways. One is, yes, if you conceive of lawyers principally as being agents for information retrieval, then indeed technology can supplant lawyers in significant ways, right? And in fact, there's another piece of that too, which is that, lawyers have constantly been on the losing end of, I shouldn't say losing end. I'd say lawyers have lost in many ways the PR battle with the public about the value that we provide, right? If AI has been more effective at identifying cancerous lesions in radiological scans than doctors have for 15 years, there still isn't a single person who wants a diagnosis from AI. They surely want the oncologist present in there, and they maybe even want the radiologist to confirm what's on the scans, right? But yet there are people who in significant measure are saying, well, how do I use an online tool to help me plan my will or do my estate planning? How do I get tax advice from AI? There's quite a lot of people that are searching tools like ChatGPT for ordinary legal advice. Of course, ChatGPT will tell you things like, I'm not a lawyer, but it'll proceed to answer. There's a great number of people in the public who will rely on that. And so we do in many ways have to reposition ourselves as being principally devoted to things like information retrieval, to understanding what else we can do, right? So one piece of this is just the thing that all professionals understand, which is you definitely want more time to think in your job. So if it is the case that you can automate some of the drudgery involved in the provision of legal services, and you can free up more time to be creative, to engage in problem solving, to help deliver justice, to do all the things that you went to law school to do in the first place, that might be good, especially if you can negotiate an intelligent division of labor between human and machine, where the technology does the things that it's good at and you do the things that you're good at. And importantly, because I've heard people make this point, especially legal tech evangelists make this point, and they say things like, lawyers can do the client service. I don't just mean client service. I mean, lawyers can sometimes do the work of actually reconciling what the technology says against what they understand the law to mean in the local context, how they understand the law to be understood, their impressions of judges, their impressions of the environment in which they're maybe helping to plan a transaction, et cetera, right? I often think about negligence in the tort law and taking precautions. And, I use some early AI tools to try to I would constantly plug in some scenarios involving when or when not to take precautions. And the bottom line is it would almost always give you a sort of probabilistic answer as to what you should do or should not do. And I would often say, well, the tort law is messier than that, right? The tort law is developed by a bunch of judges who weren't in the same room, who have dramatically different it's transsystemic. They could, it's influenced by the law of a lot of different jurisdictions. It's influenced by a lot of cases, sometimes of which stand for different principles. It has some fuzzy areas, foreseeability is halfway between probability and plausibility in the law, et cetera. And so those jagged edges are the things that you're well attuned to. And so why not use technology to help you get on a higher floor? And then you can do that difficult, creative, additional work of localizing and particularizing that information for the specific context in which you operate. I would say that's probably more exciting and funner. Bottom line is that we can do a lot more if we figure out ways to leverage the technology effectively. I'll have more to say on that, I'm sure, in the Q&A. And then the final point we put as one of our claims is one that I think is really comes out in the end of the book, especially in our chapter about where we start to get into some of the conversations around bias, or especially around things like race and gender in AI, especially AI prediction, which is that there's the possibility, the technologization of some of these things creates the possibility of what I think is an interesting and robust debate around some of these social issues. The point we made is better understanding of ourselves, law, and society will lead us to actually have to contend with the ways in which the law doesn't go far enough. I would say there's some of us that have misapprehension about what the law can achieve. And when you try to figure out ways to operationalize it using some of these AI tools, you really see the law sometimes doesn't go far enough. It has blind spots, it has gaps. Sometimes the law is actually not predictive of what the optimal sanction might be in certain social contexts, for instance. And I give you like a small example. Actually, before I get into an example, in addition to the law, us being able to diagnose some of the law's shortcomings when we technologize it, we also sometimes enable ourselves to have conversations that are slightly more focused, because everyone can kind of agree that the technology can bring certain issues to stark relief. Small example. Some of you will know in Broward County, Florida in 2016, there was a use of AI tools by a company called Northpoint. They used a tool called Compass to predict recidivism. Basically, the tool is being used to determine things like post-release and bail conditions and probation conditions for people. And what researchers found, especially investigative journalists at ProPublica and also some academics later in some confirmatory research, found is that the technology was identifying Black first-time offenders as being at greater risk of reoffending than white offenders with longer criminal histories, right? There's been a debate about that, but the long and short of it is that, okay? Now, there's two ways you can look at that. One way to look at that is to say we should never use these kinds of technologies in the context of criminal sentencing. And I actually personally hold that view. Often I can be persuaded sometimes, but yes, I agree. That is a bad outcome. That's a messy application. There might be some merit to thinking about another way to do it. There's another way to look at that too, which is to say, well, what do you expect? What is the data that's informing the prediction about optimal sentences in Broward County, Florida? Well, it's the data about the history of criminal sentencing in Broward County, Florida, which, surprise, was concerning, right? It was data with significantly disparate racial outcomes. And so you could unplug the technology, But there are a lot of people who are having the conversation about racism and sentencing in Broward County, Florida, who were maybe blind to it when it was happening in the old school analog way. I think about the thought experiment of imagine a world where all our wages were just set algorithmically. I've used this example before. You upload your LinkedIn page to some wage setter, right? Tool. What would that do? Well, absent some other intervention, and if done irresponsibly, it would project a gender wage gap into the future because it would be based on historical data about wages. And if, the designers of the tool are worth their salt, it might also be attentive to things like resumes and what the gaps in people's resumes are, right? The most recent Nobel Prize winner in economics did her work on the motherhood tax, where she pointed out that women are disproportionately punished in their wages for gaps in their resume that are attributable to things like child rearing. And so if that happened, if we had a tool like that, we would be falling over ourselves to unplug it first, right? Which is maybe the sensible response. But the gender wage gap persists in our society, but it's embedded in institutions and exists in a diffuse way, right? And it's reified through relationships. And there seems to be insufficient political will to contend with it in that context. And so there's a way in which the technologization of these things bring the social issues that already exist into really stark relief in ways that could lead to sometimes productive conversations. Now, the social cost of those conversations going bad is very high, right? It could be disastrous. The key point here is not that that's the reason we should use the tech. The point is that the use of the tech and the proliferation of the tech, which is unavoidable, should continue to stimulate conversations about those issues, and the tech shouldn't take us off the hook either, right? You could take the traditionalist view and say, we should do criminal sentencing the old analog way, or the current analog way, and I might agree with you, but what I don't want is for us to be moving away from the technology by saying that's biased and racist and we're not, right? So I think that's an important byproduct of technologization in this context. Okay, I'll say one more thing and then I'll pass the floor to Patrick, which is there's more work to be done here, because in the time since we wrote the book, there's been an explosion in the use of AI in not just in law firms and legal organizations and legal settings, but by the administrative state and by the judiciary in really major contexts. And so one of the things that we need to contend with now is not just, is it going to be transformative, but are we building the right tools for the environment in which they're currently being used? And do we have the sort of right set of restraints? And so I'd invite some questions about that as well. Thanks.
All right.
Oops. You get it.
All right. Just so that we don't get into horrible feedback loops. All right. Thank you. Thank you, Benjamin and Abdi. So I will do my best to stick to time. I'll start by saying that well, thanks for I'll repeat Vincent's thank you for coming and discussing with us. And I'm glad to have the opportunity to comment on your book. And I want to begin with a bit of praise, because I see from reading the book that you've put thought and care into it, and I hope that my comments and questions are seen as equally thoughtful and careful, especially since, as I think will become clear, I do take issues with aspects, and I take the point that perhaps was the point of writing the book, but yeah. So before moving to the comments, my comments or questions, I'd like to state two quick points at the outset. The first relates to the format of today's event. So I was tasked with providing comments and questions regarding an entire book. Now, as Abdi just said, of course, the book is not especially long, and I have to say it's a breezy read, and so you deserve praise for the crispness of the prose. It's a breezy read, but it's still a book. And so you raise a number of interesting questions there. You do it just in your presentation. I mean, there's a lot here. So I mean, and I had 15 to 20 minutes, and so I'm going to be in mode of maybe cherry picking and perhaps stark contrast more than in something very fine grained and granular. I hope you forgive me for this, and also So it might be a bit cherry picking, but I hope I'm not taken as nitpicking. So I think there is a difference, and so we'll see if all of this is fruitful. And once again, all of this with the view of perhaps making the discussion more interesting for those in the audience, especially those who haven't read the book. So anyways. So the second point of context is that, I mean, I'm very much a newcomer to the questions of artificial intelligence and law. If you find my perspective somewhat off base, perhaps my newcomer status might explain why. That said, I think there's value in my commentary, despite my novice status, if you will, in the core subject matter, because I mean, this book is really aimed at converting readers to a vision. You write at the very end of chapter 1, the vision of the legal singularity is one of elevating the capabilities and ambitions of our laws and legal institutions to the highest practical level, by leveraging technology, human ingenuity, and our collective moral imagination. And in the conclusion, you write that the first goal of your book was to firmly root the idea of the legal singularity in the popular imagination. So these are, this is big stuff. And and not only is it big stuff, but you make it clear throughout the book and also in your presentation, you are saying that this has implications for far more people than just tech law people or people interested in artificial intelligence. I mean, you present a grand, even sweeping vision, which has implications for essentially everyone in society. Indeed, you say that at the end of the book, our hope is that the book will invite meaningful conversations and inspire collective action towards a future where AI-powered legal tools enhance and enrich the pursuit of justice for all. Heady stuff. And the opening paragraph, you write that over the coming decades, the emergence of the legal singularity will fundamentally transform our existing legal systems and with them our societies. Once again, heady stuff. So despite being a novice in the core subject matter, if you will, I think, or at least hope, that there's value in some tidbits of what I have to say, precisely because you're looking with this book to convert pretty much everyone to a certain vision, or at least to a project. And I mean, there are quotes galore throughout the book, and you make a forceful case in favor of this conversion. So this case, as far as I'm concerned, we're all lawyers here, it needs to convince those beyond the already converted, including newcomers to the field, such as myself. So here we go. Where do I stand? And to keep things crisp, I'll start by taking position regarding the question: have I been converted to your vision? And in the classic lawyerly fashion that you mention at the beginning of chapter 4, I'll say, well, it depends. So on what does it depend? It depends on the types of claims that are being made in the book. And like I said, there are many types of claims. There's a lot of stuff. And I think that's, perhaps the value for many readers who are considering, reading the book. Read it. It's a breezy read, and there's a lot for a lot of people. Now, some of these claims are, so I'll be clear, and I think I think that your presentation has helped clarify that even more. So some claims are directed explicitly towards the future. I know you don't, it comes off as predictions sometimes. For instance, in chapter 1, you repeat 3 times, we are on the path to legal singularity. It's the first sentence of the book. It's the last sentence of chapter 1, and it's also there in somewhere else in chapter 1. So now, I know that you're not saying that the legal singularity is inevitable. You're not making technological predictions, but nonetheless, a sense of inevitability does emanate from reading the book. And so maybe this is just a byproduct of your forceful style, but it's there. In any case, I don't want to take issue with it. I'm not in the future business. And so insofar that you have a thesis regarding things that will come to pass, I'll leave that for another time. Another set of claims made by the authors relate to the impact, when I say the authors, sorry, I'm reading my notes sometimes, made by my colleagues, the authors, Benjamin and Abdi. So another set of claims relates to the impact of information technology on legal practice. And I think this is really where the good stuff is and the meat is. Now, insofar that a great number of these claims are narrow, and I don't want to haggle over now, just they're narrow, they're closely tied to matters of information technology and computation capability, I find much to agree with. And once again, I'll repeat, I find the book worth reading for anyone who wants to stimulate their imagination regarding potential applications of information technology, or the preferred term in the book, so computation, legal computation, computation in lawmaking. And a lot of these points, you know, I hadn't thought of them before, and then in reading, I thought of them in preparing this, and coming away with them, I have to say that they seem reasonably uncontestable, well established. I don't see much room for controversy on those points. So for instance, I think we can all be on board and on the same page that there's no doubt that large language models, or LLMs in the ChatGPT style, or even better, right, even better machines, are a technological revolution in information processing. And it seems impossible to deny that such machines can drastically change how a lot of legal work is done. And I think especially the dimension of synthesis of legal materials at a speed and scale that was really unimaginable before. I see this as a great strength and an opportunity, and that the legal community ought to, and perhaps beyond, ought to seize on these opportunities. And the case is very strong. So to give the example of the reasonable person in negligence, I mean, it's undeniable. These machines can pick out and neatly synthesize factual nuances across tens of thousands, hundreds of thousands, whatever, an unfathomable number of cases. And in so doing, they can provide an interesting perspective on the factors that courts have considered important in the past, and therefore, you know, help to assess strengths and weaknesses of cases. Generate predictions, right? So they also show a lot of potential in, well, in all these other areas where it's very fact driven. So damage awards is one instance. So right now, anybody who's done, we know that it's painstaking work to create tables that give a picture of damage awards that, you know, give a sense of, well, how certain injuries are valued. And we agree that, you know, there should be consistency in these things, and machines can do the work better and faster. In the book, there's the example of another immigration law, which is another very fine-grained, often very factually led administrative law type of decision making, where, once again, going through, and you have a ridiculous number of cases, you could go through them and synthesize and create maps of, you know, what happened, find outliers, and so on. So many opportunities. The issue is sorting them out. And the opportunities so far I mentioned are, like I said, I don't take much issue with them. But then there's the ones that you go that are quite different, I think, that to me are not just broad, but even sweeping. And these aren't so much, yes, they're claims about the impact of technology and computation, but they're less with like I said, the data processing or the narrower technological claims of legal work. But the claims are intimately tied to matters of legal and political philosophy. And that's where my issues lie, even not just legal and political philosophy, but also even, you know, epistemology and so on. So that's where I see the biggest issue, and I'll focus on that since I know our time is short. I'll do my best to, you know, keep things simple and state the matter using the following distinctions. Now, these distinctions do oversimplify, but given the time we have, it's a useful heuristic. I hope you even find it useful given that you want to continue this project of having better discussions and advancing discussions. So the way I see it, the issue of computational law confronts two different ways of viewing law. And the first is what I call the technocratic view. Now, I don't use this as a slur, okay? The technocratic view, technocrat, like the power of technique, of technology. if you will. And the technocratic view is opposed to what I call, for lack of a better word, an axiological, to sound fancy, or a humanistic view. Obviously, I'm being heuristic here. I want to set up the distinction. There's gradation and so on and so forth. But let me explain the technocratic view. The technocratic view is very well exemplified by Oliver Wendell Holmes. And I was going to talk about exactly this, and you have your slides, you know, and the beautiful mustache, it's all there. So for Holmes, you've said it, systemized prediction. This is what the law is about. It's about predicting what the courts will do. In fact, the man of the future is the man of statistics, the master of economics, something or other. So yeah. Now this comes along with this. In this view, we have a very command and control view of the law. And I don't mean authoritarian here. I just mean that the law has to be clear in order to serve a regulative function and yield predictions that are as accurate as possible. And this is intimately tied to a value of valuing instrumental reasoning, which is tied to a privileging of data, of information, because it is with data that we can measure and optimize the pursuit of means with the most efficient ends. And so statistics, mathematics, geometry even, these are things that occupy an important role in the technocratic view, or the technocratic imaginary, if you will. And this is a view that is objectivist and therefore positivist in orientation. And I'm not saying any of this as a slur. I repeat, I think that all the things that I just mentioned as being part of the technocratic view are important, and that they have their place. I just want to highlight that this view entails a particular conception of law. The law is conceived in this view as a thing that is objectively there. There's information, data, and this comes across very well in your book, and that this data can be computed at varying levels of efficiency. And so my issue is not so much that the conception is false, because I think that there's some value to it and it does capture something, and I would be in trouble to say that it's false, because there's a lot of illustrious people that would disagree with me. So it's not that it's false. There's value, but I think it's a reductive view. And I think that in the view that's presented in the book, there's something reductive. Because once again, it's a very technocratic view to me that comes across. One striking metaphor that I had is you said at one point that the civil code sets out the operating system of a society. And so this, once again, it's a very instrumental technocratic idea. Now, in saying that you're reductive, or that the position is reductive, or the view is reductive, I'm well aware that you devote a good part of chapter 5 to responding to the reduction critique. And I want to say at the outset that my point on reduction is different from the one you respond to. In fact, I think that you make a convincing case of the flavor of the reduction critique that you respond to in chapter 5. I think you do a very good job of responding to it. And I don't find it convincing, not your response. I don't find that reduction critique interesting. I think that there's this essentialization of legal reasoning, and this we have to cherish the woo kind of thing. I don't find that helpful. And so I think there's, we have common ground there. But so my point about reduction, it's different, and that's where my tool of the humanistic axiological view, if you will, comes into play. So on this view, law is not this objective thing that can be computed, all right, but it's rather a matrix of practices that sustain a human community's ability to reach certain kinds of intersubjective agreement. And so the point of the law is not so much how the law reads, although that is important in many respects, but how the law reads is more the technocratic thing. How the law reads, and therefore, it tells us what to do. It's the law. Law is more about how the law should read. So another way of developing this is to say that law is something that we do more than something that is. And it is in the doing that there is value. And so to illustrate this quickly, given time, and to go to people that are more reputable than me, I will move straight to the point you make on the rule of law and close on that. So I think this is it's important also because it's one of the very strong claims that you make in the book, is that basically computational law will improve the rule of law. And so I'm going to simplify your position a little bit, but I think I'm being faithful here when I'm saying that your position is, so the rule of law is about prediction and planning, both are interconnected, and that therefore computation is good for the rule of law because you say things like the law is an indeterminate morass, it's underspecified. And that, for instance, you take issue with standards, and you say that computation will give us the precision of rules. You have a formulation, I don't remember it right now, but you take issue with standards to some extent at least, and you hope to specify them because standards are underspecified. So the idea is prediction, 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 which once again, I'm not against. But I think that in doing this and in having what is often called in the lingo the planning and prediction conception of the rule of law, this is reductive in the sense that it sells the idea of the rule of law short. And now, in saying this, I'm well aware that you are in the tradition. You're saying this is Holmes, this is Hayek, this is other very smart people. All right. The dominant conception of the rule of law is about planning and prediction. But I am more along the lines of your colleague at U of T, Vincent Chow, who says that, the rule of law is a complex normative ideal that has no canonical formulation, or to cite Jeremy Waldron, the rule of law is an essentially contested concept. And I think that the planning conception is itself reductive, and it poses a problem when we come to, thinking more holistically about the rule of law. And so I take a cue from both Chow and Waldron, where they don't reject the planning conception. They just argue for a more balanced conception because, the planning conception has balance, so it's adding. What do we add? It goes back to the idea of doing, the value of the doing. So to, let's say, cite Waldron, and so Vincent Chow calls they both talk about similar ideas, the contestation and argumentation and the doing of it law together is what is valuable, or at least it is an important part of the rule of law that gets shortchanged when we have a planning conception only. And so Waldron writes that having one's actions governed by a norm is not just a matter of finding out about the norm and conforming one's behavior to its specifications. It can involve a much more complex engagement with practical reason. The use of a standard, and let's take standards, credits a human agent not just with the ability to comply with instructions, but with the capacity to engage in practical deliberation. And so in this, and he develops this on in this idea of the rule of law and the law's thoughtfulness. And thoughtfulness is crucial, and that law, in engaging with the indeterminate morass, we are called upon, those of us who commit ourselves to being governed by the law, we engage in something together, despite all of the problems that involves, and that's where the value is. So later he writes in the same article or book chapter, the institutionalized recognition of a distinctive set of norms may be an important feature of the rule of law, but at least as important is what we do in law with the authoritative norms that we identify. So we don't just obey them and apply the sanctions that they ordain. We argue over them. We use our sense of what is at stake. And so that's the direction I'm going in. I think I'm in my time, but I know that Abdi has to leave soon, so I'm just going to cut it there. I've set up the dynamic, and we'll go from there. Thank you.
Before we go to the questions, Patrick, I just want to thank you for your intervention. I also appreciate that you charted a different course than the one that we responded to in the book, because we tried to anticipate some of the critiques in the book, but you've offered something different that we can think about, and so I really appreciate that. Thank you.
I don't see any questions yet in the box. So maybe if you'll indulge me, I just like to actually say this, which is I think you're probably making a fair critique of the way that the book presents the ideas, Patrick. But here's something to think about, which is the possibility that in the way that you've constructed your critique, there's also something overly reductionist about the way that you are characterizing what's technologically possible. And so if we go back to what I was saying at the start of kind of my context setting, if we really are 5 or 6 years, or maybe it's 15 or 16, maybe it's 50 or 60 years away from an artificial superintelligence and a system that is wildly more intelligent than a Vincent Chow or a Jeremy Waldron, I think you're dramatically underappreciating the possibility of leveraging these technologies to give us a better path towards really understanding this contested idea of what the rule of law requires. And so the technological improvements can actually also lead us to better understand these philosophical debates. And so I don't think the way that it's framed actually survives the improvement in the technology. And so Holmes is probably a cartoonish view on this front. I suspect also the Vincent Chow view or the Jeremy Waldron view is also maybe less cartoonish. Maybe you're right, but it's still a cartoonish view of actually what it is that we really need to be contending with. And so I just want to flag that, because I don't think the state of our philosophical discourse or understanding around the rule of law is as of yet complete either. I think there's a lot more work to be done. I think we can leverage these technologies to improve our understanding of these fundamental concepts.
If I may, I would agree with that. I would agree with that. However, I would flip it again and say that with the same idea, and like I said, it's just, it's something that we do. So I think that philosophy is something that we do, and so the rule of law, to me, suppose we do have a superintelligence. The cool thing about it, all right, would be in what I'm defending here is to say it's not going to tell us what the rule of law is. It will propose things, because I don't conceive of the rule of law as something distinct from us doing and arguing over what the rule of law is, as opposed to, right? So now, in the physical sciences, we are in for a hell of a ride, because there, I believe in reality, okay? And so I do think that superintelligence, let's say this is where, the split between law and medicine becomes crucial. We are physical bodies, not just that, hopefully, but let's say we're physical bodies. Yeah, there's some wild stuff on the horizon, because there is matter, there is something material, and there's therefore this something outside us. Our sand, iron, whatever. These things are not things that we do. They are there. The rule of law to me is not an objective thing that will be that the machine will tell us, but insofar that we have one, it'll be like being able to play like chess, right? The super intelligent chess player, which we have now already, actually, probably in our phones. But the super intelligent chess player is not to say it can teach you how to play better chess, but it's in the doing that there is the value. So I maybe that helps to suss out.
Maybe, although then I guess I would say, well, then you're basically claiming a commitment to your view, and you're not willing to be persuaded otherwise. because I also think a super intelligent might be able to say, well, that's a very interesting point of view, Patrick. Let's have a conversation about this, and could potentially persuade you otherwise, unless you're saying this is a faith-based commitment, in which case, a super intelligence is not going to be able to persuade me that the rule of law is anything other than I'm already, willing to believe it to be, in which case that's okay. But that's a simple belief or a commitment, right?
Okay. I don't think that's what I'm doing. But this takes us on the fun stuff of knowledge versus belief. And so I think that in matters of law, we can't do without belief at some point. And some might take serious contention to this, but this is, once again, something that we can't fully resolve here. But this distinction, age old, between knowledge and belief is at stake in what you just told me, Benjamin. And so I pose, and this is taking us way beyond, I think this is perhaps why this is such a stimulating, potentially stimulating discussion and area, because these machines are putting us in a situation that we hadn't, like, it shuffles a lot of things. And so I think that you're saying I'm putting myself in a position where it's just a faith-based commitment or whatever. Like I said, I think we need to talk about knowledge and knowledge as opposed to belief in light of your response. And I think we're probably out of time. At least I don't want to muscle Abdi out of the discussion or just make this about some big, Plato thing.
If you permit me, I made a promise to Abdi, because he has a plane to take. I make the promise that we finish the conference as.
But now I feel bad. I mean, I could disappear and you could continue this. I'll watch it on YouTube or whatever.
I don't want to speak on your back. So I make a promise, even if I see a question of Philippe Louis. Your book, as you mentioned, Abdi, was an invitation of dialogue, and thank you for that. And you see that Patrick exactly answered to that command. And I'm a AI specialist. I usually work, more on the principles that we apply when we develop an AI. But I think we have first, we need first to have this high-level discussion about the place as a lawyer, but also as a lay people, we have to consider for the near future. So thank you for that. One more time, I think it's important to read the book of Abdi and Benjamin. Thank you to Patrick, and thank you. I don't know if you don't see the copy of the book of your book, but there is a lot of post-it in it, and you read it for sure from the beginning to the end.
Thank you.
So thank you so much for your time, and thank you for all the people in the audience. Fascinating discussion, as Jean-Frédéric mentioned. So thank you for that.
Take
Pleasure.
Thanks, everybody. It's been a real pleasure. Thanks, Patrick, for your thoughtful critique.
Pleasure.